Please be ready for a dictation of exercise number 21. It's a legal exercise from February 2021 issue of Progressive Magazine. 5 seconds. Start. The observation in Ram Das that the High Court, in exercise of its revisional jurisdiction, cannot act as an appellate court, and it is impermissible for the High Court to reassess the evidence in a revision petition filed under Section 25 of the Act is in accord with Rukmini case. Its observation that the High Court can interfere with incorrect finding of fact must be understood in the context where such finding is perverse, based on no evidence or misreading of the evidence, or such finding has been arrived at by ignoring or overlooking the material evidence, or such finding is so grossly erroneous that if allowed to stand will occasion in miscarriage of justice. Ram Das does not hold that the High Court may interfere with the findings of fact because on reappreciation of the evidence its view is different from that of the first appellate court or authority. The decision of this court in V.M. Mohan is again in line with the judgment of this court. So far as the judgment in Ram Das versus Ishwar Chandar is concerned, the court limited its finding. Insofar as the 3-judge bench decision of this court in Ram Das is concerned, it rightly observes that revisional power is subject to well-known limitations inherent in all the revisional jurisdictions, and the matter essentially turns on the language of the statute investing the jurisdiction. We do not think that there can ever be objection to the above statement. The controversy centers around the following observation in Ram Das, that jurisdiction enables the Court of Revision in appropriate cases to examine the correctness of the findings of facts. Also, it is suggested that by observing so, the 3-judge bench in Ram Das has enabled the High Court to interfere with the findings of fact by reappreciating the evidence. We do not think that the 3-judge bench has gone to that extent in Ram Das. The observation in Ram Das that as the expression used conferring revisional jurisdiction is legality and propriety, the High Court has wider jurisdiction, obviously means that the power of revision vested in the High Court in the statute is wider than the power conferred on it under Section 115 of the Code of Civil Procedure. It is not confined to the jurisdictional error alone. However, the examination is limited to satisfy that the law is followed. Whether or not a finding of fact recorded by the subordinate court is according to law is required to be seen on the touchstone whether such finding of fact is based on some legal evidence or it suffers from any illegality like misreading of the evidence or overlooking and ignoring the material evidence altogether or suffers from perversity or any such illegality or such finding has resulted in gross miscarriage of justice. Ram Das does not lay down as a proposition of law that the revisional power of the High Court under the Rent Control Act is as wide as that of the appellate court or the appellate authority, or such power is co-extensive with that of the appellate authority, or that the concluded finding of fact recorded by the original authority or the appellate authority can be interfered with by the High Court by reappreciating evidence, because revisional court is not in agreement with the finding of fact recorded by the court below. Ram Das does not exposit that the revisional power conferred upon the High Court is as wide as an appellate power to reappraise or reassess the evidence for coming to a different finding contrary to the finding recorded by the court below. Rather, it emphasizes that while examining the correctness of findings of fact, the revisional court is not the second court of first appeal. Ram Das does not cross the limits of revisional court as explained in Datta case. So, holding the 5-judge bench answered the reference, we hold as we must that none of the above rent control acts entitles the High Court to interfere with the findings of fact recorded by the first appellate court or appellate authority, because on reappreciation of the evidence, its view is different from the court below. The consideration or examination of the evidence by the High Court in revisional jurisdiction under these acts is confined to find out that finding of facts recorded by the court are according to law and does not suffer from any error of law. A finding of fact recorded by court, if perverse or has been arrived at without consideration of the material evidence or such finding is based on no evidence or misreading of the evidence, or is grossly erroneous, that if allowed to stand, it would result in gross miscarriage of justice, is open to correction because it is not treated as a finding according to law. Stop.